So let me deal with the more common version first, and that's when a creditor challenges the discharge of a debt. And that's typically, as I said a little earlier in a prior question, when the creditor feels it can establish to the judge's satisfaction that the debt was incurred either through fraud or through a breach of a fiduciary duty or through doing willful and malicious harm to a person or property. So there, a creditor is going to initiate that lawsuit, and it'll probably be a lawsuit before a bankruptcy judge. As I said earlier, it's very rare to get a jury trial. Generally, there is rare as hen's teeth in bankruptcy. So that's typically when a creditor is going to initiate it. Now, occasionally you'll see a creditor initiate a more sweeping kind of non-dischargeability lawsuit. Rather than challenging the discharge of that particular debt, the creditor might challenge the entire discharge. And this might be because it looks like the debtor has played fast and loose with the facts in the bankruptcy case. So challenging the discharge of a particular debt is generally challenging the discharge based on what the debtor did before filing the bankruptcy petition. Well, this guy defrauded me. He lied to me and induced me to invest in this scheme, and now it turns out that it was all a scam. That's from something that happened prior to filing the bankruptcy papers. Somebody might challenge the entire discharge because the debtor engaged in post-petition, that is, after filing the bankruptcy petition, bad behavior. Maybe the debtor destroyed records so that the trustee couldn't investigate. Maybe the debtor lied in the bankruptcy papers and hid assets. That is a different sort of challenge to discharge. That's not just challenging the discharge of a particular debt, but challenging the entire discharge. Or let's say a debtor has engaged in fraudulent transfers during the 1 year prior to filing. Then in a Chapter 7 case, the debtor is not eligible to get a Chapter 7 discharge, but of course there has to be a court determination that there really was a fraudulent transfer during that 1 year pre-petition period. So that might be another type of creditor initiated or even trustee initiated lawsuit. Now, the question also said, when might a debtor file a lawsuit asking the court to determine whether a particular debt will remain? There are two settings. Well, even I had a case some years ago with a third situation in which I was representing a debtor, and we challenged the non-dischargeability of a particular debt. So I'll give you three possible settings. The first is student loans. Now, generally speaking, you can't get rid of student loans in bankruptcy unless it would be an undue hardship for you to have to repay them. Well, that sounds a little vague, doesn't it? An undue hardship. There is a case out of New York from a fair number of years ago called In re Brunner, and out of that came the so-called Brunner test. It's a three-part test to determine whether the debtor can discharge a student debt in bankruptcy. It's fact-specific, and it can't be, well, you know, I'm having a little trouble. I don't want to have to pay this student loan. It's a much more stringent standard that you have to satisfy. But just saying you satisfy it is not enough. You've got to get the judge to adjudicate the matter. So you might file an adversary complaint to initiate an adversary proceeding to challenge the non-dischargeability of a student loan. And there are even cases where debtors have been able to have a partial discharge of a large student debt. I will say, however, that the case law has not been favorable to debtors. And part of the reason for that is if you're a good candidate to challenge the discharge of a student loan, you probably don't have the resources to hire a really good attorney. And so you're going to be representing yourself or have somebody that's fresh out of law school. And a lot of the case law has been against debtors because they're up against some fairly sophisticated student lender attorneys. However, there have been some favorable cases dotted around the country in which debtors have been able to discharge some or all of their student debt. Another kind of debt a debtor might challenge the non-dischargeability of is tax debt. Generally speaking, a tax debt, and I think in terms primarily of income tax, can be discharged if it satisfies three requirements. Well, suppose you are convinced that your tax debt satisfies all three requirements. But let's say it's the IRS that we're dealing with here. And the IRS says, well, no, I don't think so. What about this one here? We don't think you satisfied that requirement. At that point, you may need to go before the bankruptcy judge and ask the judge to adjudicate the matter. And so sometimes there will be a lawsuit to determine, or an adversary proceeding to determine the dischargeability of a tax debt. Yet another is a debt that is to a spouse or a former spouse that is not domestic support and that was incurred during the process of a divorce decree or a separation agreement. Now, that's a bit of a mouthful. Let me back up and sort of set the stage. First, let's think in terms of Chapter 7. In Chapter 7, you cannot get rid of domestic support obligations. Well, in fact, that's true in every chapter, a domestic support obligation being child support or alimony. And you also can't get rid of a debt that isn't domestic support that you incurred to your spouse or former spouse during a divorce. A simple example can illustrate what's going on there. Let's say during the divorce judge assigned to you some of the credit card debt, let's say. Well, you go through your bankruptcy and those credit card companies can't come after you ever again. But they'll look in their records and see, wait a minute now, what about the ex-spouse? The ex-spouse is also on this. So they go to the ex-spouse and say, hey, pay up. Say, no, the divorce judge assigned this debt to my ex-spouse. You have to go after that person. And they'll say, no, you can't shuffle papers between the two of you and prejudice our rights. You owe us money. At that point, the ex-spouse will go back to the divorce judge and say, Your Honor, you told my ex-spouse to pay these debts. My ex-spouse isn't doing it. Order that person to pay me so I can pay the credit cards. Well, then that divorce judge will do so. But if it's a Chapter 13 bankruptcy, that kind of a debt is dischargeable. Now, the domestic support still is not dischargeable. You owe back child support or alimony, you're going to have to pay it. But if, let's say, you had debts assigned to you in a divorce decree, that kind of a debt is dischargeable in bankruptcy, both vis-a-vis the credit card company and the ex-spouse. There have been some cases in which certain debts that were incurred as part of the separation agreement or divorce decree have been considered domestic support, even though they don't really fall within the child support or alimony categories. So you might, if you're the debtor in a Chapter 13, want to initiate an adversary proceeding to challenge the non-dischargeability of this debt that was assigned to you in the divorce decree. So those are three in which a debtor might initiate a lawsuit to challenge the discharge or challenge the non-dischargeability of a debt. So in sum, sometimes a creditor will initiate the non-dischargeability adversary either to challenge the discharge of a particular debt or to challenge the discharge of all the debts. And then sometimes the debtor will initiate to challenge the non-dischargeability of particular debts.